Thank you, Corla. And I'm glad to have the opportunity to contribute to the debate this evening on the Companies Amendment Act 2014. And I'd like to commend Deputy Donnelly and his team for putting together this legislation and bringing it before the House tonight. Deputy Donnelly's bill seeks to make examinership cheaper and more viable option for companies that are in difficulty and at risk of receivership or insolvency. And I think that's a very clear statement in relation to this legislation. And when you consider that last year 360 firms went into receivership and only 21 entered examinership, it shows that there must be something particularly wrong with the system as it stands at the moment. And Deputy Donnelly bill seeks to make it easier for companies to enter examinership and enable a third party to come up with ways of restructuring the business so as to protect jobs. And I think that's what the tenet of this bill, and I think the government should be looking at it on that basis in terms of wanting to protect jobs and keep as many companies as possible operating in the state. Because I believe that it's only when companies can continue to operate and continue to trade and work their way out of their difficulties with the protection of an examinership process that they will be able to actually contribute, and their creditors will actually stand a better chance of getting their money back than if a company goes into receivership. The Minister, in outlining his opposition to the bill, has stated that it weakens the position of creditors. I don't understand how that can be, and I've listened to a lot of the debate over the last 2 nights, and I still haven't been satisfied as to how that is the case, that it weakens the position of creditors. As I understand it, if a company goes into receivership, then you have the preferred creditors and the priority creditors are all dealt with, and the priority creditors are the state, the revenue commissioners, the PRSI, PAYE, VAT, they all get dealt with first, and then the secured creditors might get dealt with, and then the other ordinary creditors, if there's anything left over, will get a proportion of what they actually is left over in that situation. Now it stands to reason that in a situation of a receivership, that actually there'll be very little left over because the company is gone and all the assets have gone, and plus the state and the secured creditors have taken priority, and so there'll be very little left for SMEs who are doing business with the SME that has gone out of business to actually receive. But in the position of examinership, the company continues trading, has the chance to trade out of its difficulties, and the creditors then can receive a larger portion of what they've been owed. Now, okay, they may be put in the position of having to maybe do a deal or take a write-down in what they're owed in the process of the examinership to get to a situation where the company can continue trading, but surely in that situation they stand a better chance of recovering their debt. And I think that stands to reason. Now, maybe I'm completely wrong in my read of this, but that seems to me to be the situation, and it seems to me that that would be a better situation than forcing companies into receivership and disposing of their assets and forcing huge write-downs on all the creditors. And I listened to Deputy McHugh there a couple of minutes ago talking about subby busters and how companies go into liquidation and set up again and subcontractors lose out and how they should be protected. But that means nothing in relation to this bill, because the company that's going to do that is going to do it anyway. And even if this legislation was passed, they're not going to opt to go into examinership. They're going to go straight into receivership anyway, and they're going to burn the subbies and everything else. So they need protection from other legislation, and this legislation wouldn't impact on their situation in any way at all. Under this legislation, the examiner would have the power to reduce the leases, upward-only leases that companies have maybe paid into in order to make them viable into the future. And I think that's something that's very laudable and very possible and should be done and should be continued on. And that, I mean, Fine Gael spoke long and hard before the general election about how they were going to end upward-only rents, but this gives an opportunity for a business that can be viable to actually get a rent that makes them sustainable and keeps them viable into the future. So in all of this seems to be all about creditors and protecting creditors, but I don't see how the argument has been made and how it can stand up. I wonder, when the Minister talks about protecting creditors, is he talking really about protecting the state and making sure that the state gets its taxes that are due and gets its VAT that's due and gets its PRSI and PAYE, and it's better for the state maybe if a company goes into a liquidation to ensure that they recover all those debts first before anybody else can get a look in relation to recovering from a company that has failed. And the Minister also mentioned property rights in this, and this to me I think is the biggest cop-out that ever we see in this House. And it comes up so often: property rights, property rights. Property rights are sacrosanct, and nothing can be done that would ever affect with property rights. But property rights are enshrined in the Constitution, and they're outlined in Article 43. But in Article 43 too, property rights and the right to property is actually, there's conditionality placed on it. But no government seems to have the neck or the balls to actually test this and to bring forward legislation that can actually stand up against this. Article 43(2)(1 says that property rights should be qualified in terms of, in civil society, in terms of social justice. Surely it's social justice to allow people to continue at work, to allow businesses to continue to trade, and to allow them to operate for the betterment of society. And Article 43(2)(2 says that property rights should be qualified in terms of the common good. Is it not in the common good to keep people in employment and keep the situation going and keep everybody working? Surely that should be tested by a government, and a government should stand up and test that under the Constitution.